Good afternoon, class. We are continuing our lecture on the law on obligations. We will still be talking about Chapter 3, the different kinds of obligations. Our source material, once again, is Obligations and Contracts by De Leon and De Leon Jr. So we will continue with Section 4 of Chapter 3. We will talk about joint and solidary obligations. So before we begin with that, we have to identify first the kinds of obligations according to the number of parties. So remember, individual obligation, one obligor, one obligee, one debtor, one creditor, differently stated. Collective obligation when there are two or more debtors and or two or more creditors. So in a collective obligation, it can happen na one debtor, several creditors, or several debtors, one creditor, or pwedeng several creditors and several debtors. Basta merong plurality, even on the side of only one of the parties, remember it is known as your collective obligations. Now, there are two kinds of collective obligations. Yung joint obligations, it is one where the whole obligation is to be paid or fulfilled proportionately by the different debtors and or is to be demanded proportionately by the different creditors. So remember, sa isang joint obligation, kung ikaw ang debtor, ang outlook mo lang, ang iyong problema lang is paano mababayaran yung utang mo sa isang particular creditor. Now, kung marami kang creditors, ang portion lamang ng utang mo to that particular creditor ang babayaran mo, not your entire debt to all the creditors. So, yun ang tandaan natin. So, anyway, please take note of yung term na to each his own. So, yun ang tatandaan natin when it comes to a joint obligation. Kanya-kanya ang bayad. So, kung isa kang debtor, ang babayaran mo lang is yung utang mo. But remember, meron kang co-debtors. And remember also that if you have several creditors, ang babayaran mo sa bawat isang creditor mo is yung portion lang which is owing to that creditor. Kaya nga ang sabi dito, each obligor answers only for a part of the whole liability and to each obligee belongs only a part of the correlative rights. So also, on the part of the creditor, ang pwede mo lang singilin is yung portion na pinautang mo. So, kung ang pinautang mo is ganitong amount, yun lang ang pwede mong singilin. Although meron kang co-creditors. So, remember, yung co-creditors, bahala silang maningil ng utang sa kanila. But also, ang tandaan nyo rin dyan is if you are a creditor, you can only demand yung portion pertaining to one particular debtor. Anyway, pagka nag-example tayo, malilinawan yan. Please take note also na doon sa solidary obligation. So, solidary obligation, each one of the debtor is bound to render and or each one of the creditor has the right to demand from any of the debtors entire compliance with the prestation. Meaning, any creditor can demand from any debtor yung buong amount. So, kung ikaw ay debtor, pagka nag-demand ang isang creditor, ikaw ay solidary debtor, remember, you have to pay for the entire obligation, subject to exceptions as we will later on know. Also, if you are a creditor, you can collect the entire amount belonging to even those that do not belong to you or belong to your co-creditors. So, pwede mong i-collect yung buong yun. So, remember, the relationship here between the creditors and debtors is so close that each of the former or of the latter may demand fulfillment of or must comply with the entire obligation. Close daw sila, class. So, yung mga debtors, aabunuhan niya yung utang ng ibang debtor. Yung mga creditor, pwede niyang ipaningil yung credit ng mga ibang creditors. So, remember here, one for all for one. Meaning, ang mga debtor, united sila sa pagbabayad in such a way na demand on one of them will make the entire obligation due and demandable. And also on the part of the creditor, again, united sila, naningil yung isa, ipinapaningil niya lahat ng creditors. So anyway, to make it clear, we will give some examples. So anyway, before we begin with the examples, let us go back to the yung concept. Let's go back a few slides para ma-remind tayo kung ano ang mga
yung joint and solidary obligation. So anyway, joint obligation, remember the obligation is to be paid or fulfilled proportionately. Remember the term proportionately by the different debtors and or demanded proportionately again by the different creditors. Now, ang liability lang ng mga debtor is only for a part of the whole liability. And remember, yung mga creditors naman, ang kanilang right is only a portion of the uh, debt. So, again, remember yung sinabi ko, to each his own, kanya-kanya, very, very important. So, let us say, class, we have a joint obligation. So, isulat ko na lang sa aking maliit na whiteboard. Since nagre-reflect kasi class yung malaki, I cannot do anything about it. So, dito na lang tayo sa maliit yung gagamitin ko. So, anyway, same concept, joint obligation. So, remember, a joint obligation to each his own. So, let us say ang utang is, let us say, 8,000 pesos. So, 8,000 pesos, let us say there is a creditor and there are two debtors. Kasi syempre, kailangan ng plurality. So, debtor 1 and debtor 2. So, the obligation is again for 8,000 pesos. So, yun ang una muna nating tandaan. Now, itong 8,000 pesos na to, remember, ah, si creditor ang nagpalabas ng buong 8,000 na yan. But yung mga debtors natin, we have to remember also na sa mga debtors natin, ang utang lang nila dyan is tig 4,000 pesos. Now, dahil joint ito, remember that debtor 1, wala siyang pakialam kay debtor 2. Kanya-kanya nga, to each his own. So, itong si debtor 1 has no obligation to represent debtor 2. Now, let us say creditor demands from debtor 1. Magkano ang kailangan ibayad ni debtor 1? Remember, only 4,000 pesos. Bakit 4,000 lamang? Kasi yun lang naman ang utang ni debtor 1. And remember, debtor 1 has no obligation to represent debtor 2. So that is what you have to remember about a joint obligation, kanya-kanya. Now, what if same amount of debt? Let us say again 8,000 pesos yung pagkakautang. Let us say now palitan natin. Dalawa na ang creditor ngayon and let us say iisa ang debtor. So, meron tayong one debtor and creditor 1 and creditor 2. So, remember sa credit na yan, yung 8,000, it belongs to both C1 and C2. So, uh, they have a credit of 4,000 pesos each. So, si creditor 1, 4,000. Si creditor 2 ay 4,000 din. So remember, if creditor 1 demands payment from debtor 1, ang masisingil lang ni creditor 1 is again 4,000 pesos. Bakit hindi po 8,000? Kasi remember, creditor 1 has no obligation to represent a creditor 2. So kung gustong mabayaran ni creditor 2, creditor 2 must demand from debtor 1 yung payment ng kanyang obligation. So yun ang tandaan natin pagka dalawa naman ang creditors. Now, what if class, let us say, the debt is, let us say, 6,000 pesos. Tapos, meron tayong dalawang creditors. Tapos, meron din tayong dalawang debtors. Yan. So, remember class, si creditor 1, what belongs to him only is 3,000. Yun ang portion niya sa credit. And si creditor 2 also, ang kanyang portion sa credit na yan is 3,000 also. Debtor, ang kanyang utang sa 6,000 na yan is again 3,000 only. And also debtor 2, 3,000 only. Now, remember class, itong si creditor 1, if creditor demands from debtor 1, yung kanyang credit is, let us say, sinabi ko sa inyo kanina, 3,000, di ba? Pero yung 3,000 na yan, remember, it does not, it belongs, ang nangutang sa 3,000 na yan actually is, remember, debtor 1, ay hindi na siya masyadong makita. So, debtor 1 and also debtor 2. So, yun ang tandaan natin. So, yung 3,000 na obligation ay na credit ni C1 is actually divided to debtor 1 and debtor 2. So, if C1 demands payment from debtor 1, remember, C1 can only demand 1,500 pesos from debtor 1. Kasi, yun lang naman ang portion ng utang ni debtor 1 kay creditor 1. Now, kung si creditor 1 gusto niyang mabuo yung kanyang 3,000 na credit, creditor 1 has to demand magkano na naman? 1,500 from debtor 2. Now, itong si creditor 2, syempre, kung hindi siya maniningil, hindi siya mababayaran. Creditor 2 has to demand, magkano rin? 1,500 from debtor 1. And creditor 2, para mabuo yung kanyang credit na 3,000, has to demand again 1,500 from debtor 2. Now, what if the problem is this? Let us say we have two creditors, creditor 1 and creditor 2, but we have three debtors, debtors 1, debtor 2, and debtor 3. So we have three debtors and two creditors. Now, let us say, class, the debt is uh, let us say 6,000 pesos na naman. Yan. So 6,000 pesos. So remember here, class, that ang share ni creditor 1 sa debt na yan, ay credit niya is 3,000. Si creditor 2, meron din siyang credit na 3,000. Now also remember here that itong si debtor, 6,000 na amount na yan, ang utang lang talaga niya actually is 2,000. Si debtor 2, 2,000 din. And si debtor 3, 2,000 din ang kanyang utang. Now, kung ito ay joint, remember, para mabayaran si C1, he has to make a demand on D1. Also, C1 has to make a demand on D2. C1 also has to make a demand on D3. Because remember, D1 cannot represent D2, D1 cannot represent D3. So, demand must be made on all of the debtors. Now, if C1 demands payment from D1, remember that D1 only has to pay magkano? Remember, D1 has to pay only 1,000 pesos. So, remember, 1,000 pesos. Bakit? Kasi remember, ang itong 3,000 na credit ni C1, tatlo silang naghati yan. D1, D2, and D3. So, remember, C1 is required, is allowed only to demand 1,000 from D1. Ma'am slash, sir, paano ba yung, paano yung credit ni C1 is 3,000? Yun ang inutang sa kanya. Sabi ko nga kanina, demand from debtor 2, demand again from debtor 3 para mabuo niya yung kanyang 3,000 pesos. Same is true with C2. Remember, class, si C2, kailangan niya mag-demand from D1, D2, and D3. So, as you can see, class, in a joint obligation, the obligation is divided into as many creditors and debtors as there are. So, kung ilan ang creditors and debtors, ganun din karami ang obligations sa isang joint obligation. Now, what if pagbalik rin natin? Let us say the obligation is 12,000 pesos. Yan. Tapos, we have two creditors, creditor 1 and creditor 2 and creditor 3 pala. 3 na lang pala. And we have two debtors, debtor 1 and debtor 2. Remember, in the obligation, ang debt lang ni debtor is, remember, 6,000. Ang debt ni debtor dyan is, debtor 2 dyan is also 6,000. Now, in terms of credit, remember, ang credit lang ni creditor 1 dyan is 4,000, creditor 2, 4,000, and creditor 3, 4,000 pesos. Now, if C1 wants to demand from D1, ang pwede lang niyang i-demand is halagang magkano. Remember, class, that here, C1 is allowed only to demand up to 2,000 pesos only. Ma'am, paano niya mabubuo yung 4K niya? Again, demand from D2. 2,000 again. So, buo na yung 4K niya. Ma'am, paano si C2 at saka si C3? Again, sabi ko nga sa inyo, demand from D1, 2K. C2 mas demand from D2, 2K. Tapos C3 demand from D1, 2K. And C3 mas demand from D2, 2K. Para makuha nila yung kanilang proportionate na credit from the debtors. Again, C1 is not allowed to represent C2 and C3. C2 is not allowed to represent C1 and C3. C3 is not allowed to represent C1 and C2. Also, D1 is not liable for the debt of D2. Same is true with D2. He is not liable for the debt of D1. Now, what if the debt is solidary? Yan, sinulat ko na yung solidary kanina habang nakapause yung video. Anyway, let us say, class, the debt is 8,000 again. Paborito ko yata yung 8,000. So, anyway, 8,000 is the debt. Let us say we have one creditor. And let us say we have two debtors, D1 and D2. Remember, the creditor, if he demands payment from D1, is allowed to recover 8,000 pesos. Bakit? Because D1 is will represent D2 in the obligation. Remember here, D1 ang utang talaga niya is 4,000 lang. Pero dahil meron ng mutual representation between solidary debtors, si D1, ire-represent din niya si D2 and D2 has to pay, D2 must reimburse D1 later on. Now, what if dadagdagan ko C1 and C2? So again, if C1 demands payment from D1, same is true. Ang ibabayad pa rin ni C1 ay ni D1 kay C1 ay 8,000 pa rin. Bakit? Because again, merong mutual agency between C1 and C2. So si C1, pwede niyang ipaningil si C2. So yung portion of the credit owing to C2, pwedeng singilin ni C1 mula kay D1, and si D1 again, kailangan niyang i-represent si D2. And siya yung mag-aabono muna nung yung utang ni D2. Now, after maningil ni C1, kasi nga siya yung binayaran, C1 must give yung share ni C2. So, yun ang tandaan natin. Now, what if gawin pa nating tatlo ang mga debtors? O yan, C1, C2, and D1, D2, and D3. If again, C1 demands from D1, remember, D1 has to pay again 8,000 pesos. Kasi nga, sabi ko nga sa inyo, D1 will represent D2 and D3. Later on, D3 must reimburse D1 dun sa kanyang inabunuhan. Ngayon, itong si C1, pwede niyang ipangsingil itong si C2 and later on, ibibigay niya yung nasingil niya kay C2. Now, what if dadagdagan ko pa, gawin ko pang C3 to, C4, C5, etc., etc. Now, remember pala class, bago kayo baka makalimutan ninyo, C1, C2, and C3, any of them may make a demand on any of the debtors. So, let us say class C3 demands from D2. Again, D2 has to pay yung entire amount na 8,000 pesos. So, pwede naman. D2 will represent D1 and D3, and later D1 and D3 must reimburse D2. Tapos naman si C3 represents C2 and C1, and later on C3 must give yung portions ni C2 and C1 doon sa debt. So, in short, pagka solidary, isa lang ang maniningil, sisingilin na niya lahat. And remember, yung entire debt ang pwede niyang singilin. Now, class, our last example, what if the obligation is, let us say, 1 million pesos and we have, let us say, 4 creditors. So, let us say C1, C2, C3, and C4. Also, we have 2 debtors, debtor 1 and debtor 2. Now, remember, kung ito ay isang joint obligation, yan, balik tayo sa joint, sorry, balik tayo sa joint. Now, remember sa 1 million na yan, ang utang ni debtor 1 is actually 500,000. Ang utang ni debtor 2 is also 500,000. Yan, hindi na siya masyado nakikita. But anyway, you get the idea. Also, itong si C, ang utang niya, ang kanyang credit is 250. C2, 250 also. C3, 250. And C4, 250 also. So, anyway, you get the idea, class. So, itong si C1, if he or she is a joint debtor, demands payment from D1. Remember, itong si C1 cannot demand yung buong 250 from debtor 1 na 250 na credit niya, because remember, debtor 1 is joint debtor also. Now, if C1 demands from D1, ang madedemand lang niya is 125, and para makumpleto yung 250 niya, 125. Same is true with C2, C3, and C4. They must make demand para magkaroon sila ng bayad, because C1 cannot represent C2, C3, and C4. And also, ito naman si D1 and D2, si D2 will not be liable, D1 will not be liable for the debt of D2 and vice versa. Now, kung solidary ito, kunwari daw buburahin ko solidary. Yan. So, what if this is solidary? So, sulat ko formality lang para medyo kumpleto tayo. So, solidary. So, if this is solidary, remember, C1 can demand magkano from D1. or from any of the debtors. Halimbawa, C1 demands from D2, again, C1, D2 must pay 1 million. What if it is C3 who makes a demand on D2? Remember, again, 1 million. Kasi nga, any of the creditors can represent the other creditors, and the debtor will represent also the other debtors. But, what about if C1, C2, C3, and C4 are, let us say, solidary creditors, and D1 and D2 are joint debtors only. Yan. So, remember here, solidary yung mga creditors, joint ang mga debtors. Now, remember, itong si solidary creditor, let us say C1, demands from D1, magkano ang kailangang ibayad ni D1 dito? So, presumably, itong si C1 can collect the entire amount of 1 million pesos from debtor 1. Kasi nga si C1 is allowed to represent C2, C3, and C4. Kasi nga merong mutual agency yan. So, mutual representation. So, sana itong si creditor 1 can demand sana from debtor 1 the entire amount of the debt, which is 1 million pesos. But remember, debtor 1 is only a joint debtor. So meaning, debtor 1 cannot be allowed to represent debtor 2. So remember here, because the creditors are solidary, pwede nilang makuha yung buong amount owing to the to a specific debtor. So, ang buong utang ni debtor 1 ay 500. Remember, pwedeng singilin ni creditor 1 ay 500 pesos because 500,000 pesos. Because remember, C1 nire-represent niya si C2, C3, and C4. So, ang limit lang ng utang ni D1 is 500. Imbis na si C1 sana, sisingilin pa niya yung kanyang credit na tig magkano pa di kay D1, D2, tig 125 dapat lang sila, di ba? But remember, here because solidary, C1 can represent 2, 3, and 4. So yun ang tandaan natin sa solidary creditors and joint debtors. So obviously class, C1 or any of the creditors can demand from D2 also yung 500,000 para mabuo yung kanilang credit na 1 million pesos. Now, what if baliktarin naman natin? Gawin naman natin ang mga creditors natin ang joint creditors C1, C2, C3, and C4, and solidary debtors debtor 1 and debtor 2. So remember class, here C1, C2, and C3, and C4 are joint creditors of solidary debtors D1 and D2. So let us say class creditor 1 will try to recover from debtor 1. How much can creditor 1 recover from debtor 1? So remember here class, si creditor 1, isa siyang joint creditor. So ang masisingil lang talaga niya is actually 250,000 pesos from yung kay debtor 1. Ito namang si solidary debtor, dahil siya ay solidary, he can pay up to yung dahil siya ay solidary, remember class na dapat ang mababayaran ni debtor 1 is up to 1 million pesos, di ba? Sa totoo lang. Pero kasi itong si creditor 1, ang kaya lang talaga niyang i-recover is only 250,000. So, kahit na kayang magbayad ni debtor 1 ng 1 million, dahil nga solidary, pwede niyang i-represent si debtor 2. But because creditor 1 can only demand 250,000, ang pwede lang i-demand ni creditor dyan ay, remember, 250 from debtor 1. Ma'am, bakit ganun? Dapat, di ba, 125 lang yan. Kesyo-kesyo. Kasi yung 125 niya, dapat sisingilin niya kay debtor 2. Yes, tama sana yon kung si debtors ay joint din. But remember here, solidary si debtors. Remember, itong si debtor 1, pwede niyang ipang-abono itong si debtor 2. Because remember, sa 250 na pinautang ni creditor 1, tig 125 si debtor 1 and debtor 2. But since solidary sila, debtor 1 can represent debtor 2, kaya nga si debtor 1, magbabayad siya ng 250,000 from creditor 1. So anyway, kung hindi pa malinaw yung mga examples na yan, ewan ko na lang kung anong gagawin ko sa inyo. But during class, maybe we can give more examples kung sakaling hindi pa malinaw. But I did my best considering na ang hirap mag-illustrate. Gagawin ko sana sa sa PC na rin, ay sa laptop na rin. Kaso lang, ang hirap. I do not know what program to use. I'm trying to use Paint, but it's very hard to do that. So anyway, we will continue with our lessons. So anyway, to continue with our lessons, please take note also of yung words to indicate joint liability, mancomunada simple, pro rata, proportionately, etc., etc. And also yung mga words used to indicate solidary liability. So solidaria, insolidum, joint and or several is used to indicate solidary liability. So individually and or collectively also solidary liability. So yun ang kailangan nating tandaan pagka joint liability proportionately, or if you see promissory note or anything na may nakalagay na we promise to pay but it is signed by 2 or more persons, remember this is a joint obligation. Now if you see a promissory note na signed by 2 or more persons pero ang nakalagay is I promise to pay, remember the obligation is solidary. So anyway, collective obligations are always presumed to be joint. Pagka collective obligations, again, meron 2 or more debtors, 2 or more creditors. Tapos hindi sinabi kung ano ang share ng each debtor or creditor. Remember, the obligation is presumed to be a joint obligation. The presumption is rebuttable. Now, there will be solidary liability when the obligation expressly so states, when the law or nature of the obligation requires also a solidarity. So, kung required ng law or nature of the obligation, and if there is an express stipulation, remember, there is solidarity. But kung walang indication what kind of obligation it is, remember, it is presumed to be a joint obligation. Now, please take note also of the instances when the obligation is solidary. Actually, sinabi ko na to kanina. When number 1, there's a stipulation in the contract that the obligation is solidary. So, agreement. Number 2, nature of the obligation requires solidarity. And number 3, when the law declares the obligation to be solidary. So again, stipulation, nature of the obligation, and also law. Now, please take note also of the kinds of solidarity. According to parties, may be passive. So this is solidarity on the part of the debtors. So kahit na kanino mag-demand yung creditor, the debtor must comply with the entire obligation. Active solidarity is solidarity on the part of the creditor. So any one of the creditors can demand fulfillment of the entire obligation from the debtors. Now, mixed solidarity obviously is solidarity on the part of the debtors and creditors. Now, according to source, it can be conventional, meaning it is agreed upon by the party. Remember, again, yung solidarity must be clearly established, or else if there is no mention, the obligation is only joint. Now, legal solidarity is imposed by the law itself. Now, remember the instances of legal solidarity. So, number 1, when an agent has exceeded his authority, principal is solidarily liable with the agent. If the principal is in estoppel, so he allows the agent to act as if he has full powers. Number 2, all partners are solidarily liable with the partnership for crimes or quasi-delict and committed by any partner acting in the ordinary course of business of the partnership. So, if yung act ng isang partner is to promote business and there are crimes or quasi-delicts committed by yung partner, remember, all partners liable with the partnership. What else? 2 or more persons have appointed a common agent, an agent for a common transaction pala. They shall be solidarily liable to the agent. So, ito yung liability ng principal na nag-appoint ng agent for a common transaction. What else? Two or more bailees in commoditum to whom um, the thing is loaned in the same contract, they are liable solidarily. So remember here, two or more bailees. So um, sila yung nagpa sila yung nanghiram. So remember yung mga nanghiram in accommodatum, they are liable solidarily. What else? Two or more payees in case of payment mistaken payment. So kung dalawa ang nakatanggap ng pera um, sa isang obligation where sa isang nakatanggap lang sila ng pera where it is not due and demandable or there is solution indemnity, remember yung two or more pays na to, they are liable solidarily. So kung halimbawa dalawa kayong nakatanggap ng pera tapos the payment made to both of you is by mistake, demand on one, kailangan yung isa ipang-abono niya yung isang kasama niya. What else? The responsibility of two or more persons who are liable for quasi-delict is solidary. Common sense na lang yan. Engineer architect is also solidarily liable with contractors for damages. What else? Felony. So in a crime, principal, accomplices, and accessories shall be liable also in solidum. So pagka yung principal sa isang crime, you demand a payment from him, kailangan din niyang ipang-abono yung mga kasama niyang accomplices and also accessories doon sa crime. What else? Please take note also of real solidarity imposed by the nature of obligation. Anyway, pinag-aralan natin to kanina. These are the exceptions to the presumption of joint liability. So again, solidarity is not presumed because they are a burden upon the debtors. Because remember, class, debtor ka, dapat ang ibabayaran mo lang is yung utang mo. Pero dahil solidary, kailangan mong ipambayad yung mga ibang kasamahan mo. So here there is an increase of the responsibility of the debtors. And dun naman sa part ng creditors, there is an increase of the right of each of the creditor because yung creditor, imbis na ang masisingil lang niya is yung kanyang proportionate credit, pwede niyang singilin yung credit ng mga kasama niyang co-creditors. So, ang presumption ng law is that all collective obligations are joint unless otherwise stated. So what else? Please take note of the concept of a joint indivisible obligation. So here, obligation is joint because the parties are merely proportionately liable, but it involves an indivisible object. Again, an indivisible object, hindi pala again, an indivisible object is not physically divisible into different parts. So, joint as to liabilities but indivisible as to compliance. So, usually, ang binibigay na example sa book nyo is an obligation to give a car. So, ang car is indivisible. Hindi mo pwedeng i-deliver yan. You cannot comply with the delivery of a car if it is in parts. Kailangan buo. So, remember, indivisible as to compliance. Now, let us say, there is a creditor. The creditor is C. There are three debtors. Debtors 1, 2, and 3. They are liable to deliver yung isang car. So, yan ay isang joint indivisible obligation. So, let us say, class, the car is worth 120,000 pesos. Tapos, syempre, itong si debtors 1, 2, and 3, they have to advance yung money para mabayaran yung kotse, para mabili yung kotse. So, each of them has to spare or give 40,000 pesos para mabili yung car which is worth 120,000. Now, the question is, ma'am/sir, what if yung isa sa mga debtors walang pera? Let us say si debtor 3 has no money to give so that hindi makompleto yung pera, hindi mabili yung kotse. So, remember, because this is a joint obligation, hindi nila aabunuhan yung share ni debtor 3. Si debtors 1 and debtors 1 and 2 will not advance payment for yung obligation ni debtor 3. Hindi sila mag-aabono. So because the car cannot be given, because it cannot be bought, because D3 cannot give yung money, remember that it is converted into an obligation to give indemnity for damages. So each debtor will be proportionately liable. So ang kanilang babayaran lang is 40,000 pesos each. So D1 has to give 40,000 to the creditor. D2 has to give 40,000 to the creditor. So yung insolvent debtor, hindi pang aabono ni D1 and D2. So remember here, yung si creditor will have the rights of a creditor of an insolvent debtor. So as against D3, meron si creditor ng rights against an insolvent debtor. Now also remember here, because this is joint indivisible obligation, joint yung liabilities ng parties. So the creditor has to demand from D1, D2, and D3 also before they will become in default in complying with their obligation. So kung sa isa ka lang nag-demand, wala pang default. So kailangan mag-demand ka dun sa tatlo. So yun ang tandaan natin. Demand must be made on all the joint debtors. So if any one of the debtors does not comply with the obligation, shall be liable for damages, but the other debtors will not be liable for the share of the insolvent debtor. If joint creditors naman, delivery must be made to all of the creditors, not merely to one. What else? Demand by one joint creditor is not a demand by the other joint creditors. So anyway, this is again middle ground between joint and a solidary obligation. So the rules in case of divisibility, indivisible obligations, not necessarily solidary obligations. So remember 12:10. Indivisibility does not necessarily give rise to solidarity. So if the obligation is indivisible, hindi automatic na solidary. And also, kung solidary ang obligation, hindi automatic na indivisible yan. Yung obligation na solidary but at the same time hindi indivisible or divisible is the obligation to pay money. And the obligation to pay money is always divisible obligation. But remember, pwedeng maging solidary ang liability ng mga parties dyan. Also, in case of an indivisible obligation, pero ang liability is joint, as in the case of a joint indivisible obligation. What else? 12:11, solidarity is not affected by diverse stipulation. So, iba-iba ang stipulations, iba-iba ang due date. Yan, pwede sabihin na lang natin due date. Hindi maaapektuhan. Meron pa ring solidary liability. So let us say, class, meron tayong obligation si debtor 1, debtor 2, and debtor 3. Meron tayong isang creditor. So anyway, debtors 1, 2, and 3, meron silang obligation, let us say 12,000 kay debtor ay kay creditor. So bawat isang debtor meron siyang utang na 4,000. So 4,000 debtor 1, 4,000 debtor 2, 4,000 debtor 3. Tig ano nga sila? Tig 4 para mabuo yung 12,000. So anyway, they are solidary. So supposedly, the demand made by one creditor to one debtor, yung isang debtor na pinagdemandan, is liable to pay the entire obligation. But let us say, for example, yung obligation ni debtor 1 is due on January 1, 2022. Tapos yung obligation ni debtor 2 is due only after X finishes painting the house of the creditor, sabihin na lang natin. Tapos yung obligation ni debtor 3 is demandable the moment na pumasa siya sa CPA board exam itong October CPA board exam 2021. So anyway, let us say class, natapos na pinturahan ni Debtor 2 yung natapos ng pinturahan ni W yung bahay ni creditor. So, yung isa sa mga conditions nangyari na. So, or conditions or isa sa mga stipulations, yan, nangyari na. So, itong si creditor, remember, can demand from any of the debtors. So, pwede siya mag-demand kay debtor 1, debtor 2, debtor 3, payment ng proportionate credit lamang. Bakit? Kasi hindi pa natupad yung stipulation para dun kay debtor 3 na pumasa siya sa bar exam at yung kay debtor 1 na babayaran ng January 1, 2022. So, dahil hindi pa dumating yung dalawang yun, pwedeng maningil si creditor pero with respect only to one portion, the portion of debtor 2. Kasi nga, tapos ng pinturahan ni W yung bahay ni creditor. Now, question, isang portion lang ang pwedeng ma-demand ni creditor, kanino niya pwedeng i-demand? Remember, he can demand from anybody, even if hindi pa due yung kanilang portion. So, can demand from debtor 1, debtor 2, and debtor 3. Now, let us say, for example, after na tupad yung stipulation or yung condition or yung stipulation with respect to debtor 2, bigla natupad yung stipulation with respect to debtor 3. So, in short, pumasa si debtor 3 from pumasa sa board exam. So, remember, again, creditor can demand another portion of the debt. So, dahil ito ay pangalawang portion na, remember also that creditor can demand from any of the debtors. So, pwede mag-demand from debtor 1, debtor 2, or debtor 3. Sabihin na natin nung first time na may stipulation na natupad, nag-demand si creditor from debtor 1. Debtor 1 has to pay 4,000 pesos. Nung nangyaring stipulation 2, ay yung pangalawang stipulation, yung tungkol kay debtor 3 na pagpasa niya sa board exam. So, itong si creditor 1, can he still proceed against debtor 1? Pwede pa rin, kahit si debtor 1 uli ang magbayad. Walang problema yon. Kasi nga, solidary ang liability. So, debtor 1 can represent debtor 2 and debtor 3. So, anyway, let us say, later on, nangyari na yung third condition. So, third stipulation pala na dumating na yung January 1, 2022. So, remember class that itong creditor can demand again yung portion pertaining to the stipulation na nangyari. So, pwede siyang mag-demand again 4,000, pwedeng kay debtor 1 uli kung talagang si debtor 1 ang trip niya talaga. Pero pwede pa rin naman sa debtors 2 and 3. So, solidary pa rin ito kasi remember na the creditor can demand from any of the solidary debtors. So here, remember, there may be a solidary obligation or although the parties may not be bound in the same manner, same periods, same conditions. So, iba-iba ng condition, iba-iba ng period, okay lang. So, yun ang kailangan nating tandaan. What else? Beneficial or prejudicial act of a solidary creditor or 1212. So, remember in 1212, ang beneficial act is nakakatulong sa mga creditors. So, yung prejudicial act is nakakasama sa mga creditors. Obviously, a solidary creditor can perform a beneficial act but cannot perform a prejudicial act. So, beneficial, nakakatulong. Pwede niyang gawin yun kasi nga, nakakatulong. Prejudicial, hindi niya pwedeng gawin kasi nga, nakakasama. So, yun ang tandaan natin dyan. So, this is based on the theory of mutual agency among solidary creditors. So anyway, an example of a beneficial act to make a demand so that the prescriptive period will be interrupted. So yung prescriptive period is yung period within which to demand for an obligation. So nag-expire kasi ang mga obligations kung hindi mo na-demand kaagad. So para ma-interrupt yung pag-expire niya, make a demand. So if one solidary creditor makes a demand, it is as if all the solidary creditors makes a demand. So, what else? Prejudicial act naman, remission, condonation. Yung remission is a waiver of the right of the creditor to demand payment from the debtor. Oh, wag mo nang bayaran. Yun ang remission. So kung halimbawa yung isang solidary creditor, sinabi niya dun sa debtor, wag mo nang bayaran. Paano naman yung shares ng mga ibang solidary creditor? Kawawa naman sila. Kung ikaw yung creditor na waive ng kanyang right is hindi siya interesado sa pera, malay nyo yung ibang creditor, they are interested to get their money. That's why pwedeng i-perform ang beneficial, hindi pwede ang prejudicial. Please take note also, class of assignment by a solidary creditor of his right. So remember, as a general rule, this is not allowed. Because remember, ang mga solidary creditors, yung kanilang right is increased. So, ang solidary creditor, imbis na ang singilin lang niya is yung proportionate credit which is owing to him, pwede niyang singilin yung credit ng iba. That's why yung kanyang rights ay increased. Now, meron din silang mutual representation, mutual agency, mutual trust. Now, itong solidary creditor na to, let us say one solidary creditor 1, 2, 3. Creditor 1 assigns his right to a third person. So, itong third person na to, na assignee, pwede siyang maningil dun sa mga debtors. What if a third person suddenly absconds or escapes with the money na nasingil niya? So, pati yung portions ni creditor 2 and 3, nakuha niya. So, hindi pwede yun as a general rule, especially since ito ay may mutual trust and confidence relationship. So, baka mamaya kasi itong si creditor 1 ay siya ang may tiwala sa third person, but creditor 2 and 3, wala talaga silang tiwala because it can happen talaga na matangay yung kanilang pera. So, that is the general rule. Solidary creditor cannot assign his rights, but except when a solidary creditor will be allowed if all other solidary creditors consent. So, they will not give their consent if somehow wala talaga silang tiwala dun sa third person. Now, if the assignment is made to a co-creditor, remember here, class, that the consent of the other creditors is not necessary. So, creditor 1, 2, 3, tapos si creditor 1 assigns his right to creditor 2. So, creditor 2, hindi na kailangan ng consent ni creditor 3 dyan. Dahil nga naman, obviously, kasama na sa circle of trust itong si creditor 2. So, yun ang tandaan natin. How about 1214? Payment to any of the solidary creditors. So, here, remember, debtor may pay any one of the solidary creditors. So, but the rule also is that if a demand, so the demand may be, remember here, judicial demand or extrajudicial demand. If a demand is made by any one of the solidary creditors, to avoid confusion and also para naman hindi ma-prejudice yung right ng more diligent creditor, kasi yung more diligent creditor, siya yung naniningil, siya yung talagang interesado na mabayaran siya. Payment should be made doon sa creditor who makes a demand. So, kung sino yung nag-demand, yun ang bayaran. So, if the debtor pays a creditor who does not demand, the obligation will not be extinguished except in so far as the creditor pays share is concerned, until and unless natanggap na niya yung kanyang share. So let us say, class, tatlong creditors, creditor 1, 2, and 3. Ito ang mga creditors. Tapos let us say may dalawa tayong debtor. So anyway, creditor 1, naningil siya kay debtor 1. So debtor 1 should pay to creditor 1 kasi nga siya yung nag-demand. The demand may be judicial or extrajudicial, remember. Now, what if debtor 1, instead of paying creditor 1, pays creditor 2? So, yun ang binayaran niya. So, remember, as far as creditor 1 is concerned, di ba, pagbayad ni debtor 1 kay creditor 2, the obligation should have been extinguished. Kasi nga, solidary. So, itong si debtor 1 will represent debtor 2. Babayaran ni debtor 1 yung buong obligation kay creditor 2. Now, the obligation should have been extinguished. But remember, as to creditor 1 who demanded payment, the obligation is not extinguished, at least dun sa kanyang portion, until and unless natanggap niya yung kanyang share. So, kung hindi pa niya natatanggap yung kanyang share, remember, creditor 1 can even demand payment from the debtor again. Kasi nga, ako yung nagde-demand bakit hindi akong binayaran nyo? So, yun ang tatandaan natin sa 12:14. So, pay the creditor who demands. If the debtor pays a creditor who does not demand, the demanding creditor, or sige, the creditor who demands insofar as he is concerned, yung obligation to him, at least yung portion niya, yung obligation is not extinguished yet until and unless na binigay ni creditor 2 yung share ni creditor 1 from the obligation. So, yun ang tandaan natin. 12:15, yun namang bakit ayaw niya. So, anyway, 12:15 naman is liability of a solidary creditor in case of novation, compensation, confusion, or remission. What you have to remember about novation, compensation, confusion, or remission is that they are modes of extinguishment of obligation. So, like I said before, remission, ito yung the creditor voluntarily waives his right against the debtor. So, hindi na magko-collect itong si creditor. Ni-remit na niya yung debt, pinatawad na niya yung debt ng debtor. Hindi na niya siningil, in short. Now, remember here that ayun na nga, they are mode or causes of extinguishment of obligation. So, the creditor who executed any of these acts shall be liable to the others for their corresponding shares, considering that these acts are prejudicial. So, creditor 1, 2, 3, debtor. Isa na lang ang debtor para hindi na tayo mahirapan. So, anyway, sabi ni creditor 1 kay debtor, huwag mo nang bayaran yung utang mo. So, itong si debtor, nakakuha siya ng remission ng debt. So, di na babayaran ni debtor niyan. Creditor 2 and 3, ayaw nila. Kasi, they are interested in getting their money. So, remember here, dahil gumawa ng prejudicial act si creditor 1, which also extinguished the obligation, creditor 1 is liable for the shares of creditor 2 and creditor 3. So, yun muna for now. Compensation, again, a mode of extinguishment of obligation, yung both parties are creditors and debtors of one another. So, let us say, creditor 1, 2, 3, tapos si debtor. Si debtor, may utang siya kay creditor 1, 2, 3. Tapos itong si creditor 1 naman, meron siyang utang kay debtor. So, kumbaga, dapat si creditor 1 and si debtor is quits na sila sa utang. Kasi, may utang ako sa iyo, may utang ka sa akin. Alangan naman magbayaran pa tayo, di ba? E di quits na lang natin sa isa't isa. Yun ang compensation, quits talaga ng utang. So, itong si creditor 1, o sige, hindi ko na babayaran yung utang sa iyo, debtor 1, ay debtor, kasi isa lang pala yung debtor. Hindi ko na babayaran sa iyo yung utang, debtor. Pero ikaw, debtor, hindi mo na rin babayaran yung utang mo sa amin. So, na-extinguish yung obligation, di ba? Again, paano naman si creditor 2? Paano naman si creditor 3? So, creditor 1 has the obligation to you own nga she is liable for the shares corresponding to creditor 2 and creditor 3. So, yung concept naman ng novation, explain ko na lang, is yung changing ng obligation. So, technically, this is not a mode of extinguishment, but chine-change yung object, chine-change yung subject, ay yung object, chine-change yung parties and conditions, terms, etc., etc. But it has the effect of ending or extinguishing yung original obligation. Yun namang confusion is yung creditor, yung the personality of creditor and debtor is merged into one person. So anyway, these have the effect of extinguishing the obligation. So for now, yun muna. Later on in chapter 4, we will learn more about yung modes of extinguishment of obligations. So 12:16 naman is yung right of the creditor to proceed against any of the solidary creditors. So, above provision is not applicable to a joint obligation. Actually, if you take a look at even the title of the previous slides, rules regarding solidary obligations. Kasi, remember, meron lang tayong rules sa solidary. Kasi yung joint nga, kanya-kanya naman yan eh. Alangan naman mag-prescribe pa tayo ng rule. Utang ko, utang ko. Wala namang pakialam yung mga ibang debtor sa utang mo. Yung creditor, credit akong maniningil. So yung singil ko lang yung aking credit. Pero yung mga ibang creditors walang pakialam. So sa Solidary, dahil nga merong parang close relationship between the parties, kaya maraming rules. So anyway, creditor may proceed to as against any of the solidary debtors. So, pwedeng simultaneously or sabay-sabay, um, pwedeng isa lang, pwedeng ilan lang, pwedeng lahat sila, pwedeng simultaneous, pwedeng sabay-sabay, pwedeng successive actually. As long as hindi pa nababayaran yung buong utang, remember, solidary creditor can proceed against any one or some or all of the solidary debtors. So, kung naningil siya sa isa na solidary debtor, naningil niya si debtor 1, it is not necessarily a waiver of the right to proceed against debtor 2. So, pwede pa rin siyang maningil kay debtor 2, pwede pa rin siyang maningil kay debtor 3, etc., etc. Now, what about Article 1217, effect of payment made by a solidary debtor? Now, remember, pagka nagbayad ang isang solidary debtor, remember, it will extinguish the entire obligation. But also, here, if there are several debtors who offer to pay, the creditor, the solidary creditor, or any creditor pala, may choose which offer to accept. So, wow, maraming gustong magbayad. Kakaiba to. Alam niyo naman, pagka ikaw ay nagpautang, pahirapan ng pagbabayad. Pero ito, hindi ko maisip kung paano mangyayari ito. Pero ito, wow, maraming nag-offer. So, creditor may choose which offer to accept. Now, among the solidary debtors, so obviously, pagka nag-abono na yung isa, yung kanyang other co-debtors should reimburse him yung kanyang inabono with legal interest from the time of payment. So, paying solidary debtor can demand reimbursement from his co-debtors with legal interest only from the time of payment. Now, remember here na debtor, di ba? Tapos, tatlong debtor, tatlong creditor. So, ito yung creditor. Lagi ito yung creditor. Ito yung tatlong debtor. So, anyone may demand. Let us say, creditor 1 demands from debtor 1. So, yan, nagbayaran na sila. Ching, nagbayaran sila. So, anyway, remember here, class, na itong dalawang to should reimburse itong debtor na to. Now, kung ang liability nila, nitong tatlong nito, with respect to the creditors, ay solidary, with respect to reimbursement, ang liability ng dalawang ito is joint. Kanya-kanya sila. So, ito, kailangan niyang maningil dito. Ito, kailangan niyang maningil dito. So, the liability here is, the liability created is ordinary joint obligation. But, remember, this is not an ordinary joint obligation. Actually, yung ibang books, ang tawag nila is special. So, let us say, class, debtor 1, debtor 2, debtor 3, debtor 1 pays creditors. Tapos, di ba merong obligation of reimbursement? Si debtor 3 dapat i-reimburse si debtor 1. Si debtor 2 dapat i-reimburse si debtor 1. Now, what if debtor 3 is insolvent? Now, remember, dahil ito ay joint, but this is a special joint obligation. Itong si debtor 2, kailangan ding saluhin niya yung proportionate insolvency ni debtor 3. So, let us say ang utang na inabono ni debtor 1 is 6,000. So, sa totoo lang, tigto 2,000 sila dun, di ba? Pero, ang mangyayari dyan is, nag-abono si debtor 1 na take 6,000. So, itong si debtor 2 magre-reimburse. Ang i-reimburse ni debtor 2 ay hindi 2,000 pesos. Ang re-reimburse ni debtor 2 ay 3,000 pesos. Bakit? Sasaluhin niya yung uh, insolvency ni Debtor 3. So, itong si Debtor 3, di ba 2,000 ang share niya? Hati si Debtor 1 and Debtor 2 doon. So, parang lalabas ang inabono ni Debtor 2 ay 3,000, lalabas na inabono, ang babayaran din ni Debtor 2 ay 3,000. Siya 3,000. So, yun ang, ano ba yan, nagkakapampangan na ako. Tig 3,000 sila. So, the others, Debtor 1 and Debtor 2, assumes the share of the insolvent Debtor 3 pro rata. Yan. So, obligation of the co-debtors to reimburse the debtor payee arises only from the time payment is made. Now, among the solidary creditors, syempre, the receiving creditor is jointly liable to the others for their corresponding shares. So, receiving creditor should give yung shares ng mga other debtors, other creditors. Now, 1218, please take note of the concept of prescription. By prescription, a person may acquire rights, or by prescription, yan, one may acquire ownership and other rights through the lapse of time. Or, in the same way, rights and actions are lost by prescription. So, kung sa tagal ng panahon, nagkaroon ka ng right, ang tawag dyan ay acquisitive prescription. A-C-Q-U-I-S-I-T-I-V-E, prescription. Sa sobrang tagal ng time, bigla, nagkaroon ka ng right. Yun namang yung due to the lapse of time, rights and actions are lost. Ang tawag dyan ay extinctive prescription. E-X-T-I-N-C-T-I-V-E. So, nawalan ka ng rights kasi ang tagal-tagal na hindi ka kumikilos, nawala yung rights mo. So, anyway, for now, we will talk about prescriptive period of actions. Meaning, ito yung extinctive. Dapat ma-file mo yung mga actions, yung demanda mo, yan. Kasi sometimes we use the term actions. Dapat ma-file mo yung demanda mo or yung case mo within a certain number of years, or else magpe-prescribe or mawawala yung right mo. Extinctive prescription. So anyway, 10 years, based on a written contract, based upon an obligation created by law upon a judgment, you have 10 years to file a case. So 10 years from the time the right of action accrues. What else? Within 6 years from the time the right of action accrues. So it can happen in case of an oral contract or upon a quasi-contract. So kung may quasi-contract, like solution indemnity, you have 6 years to file an action to recover your money. Kung solution indemnity, meron kang 6 years if you are the gestor in negosyorum gestio to recover yung necessary and useful expenses mo from the property owner. Now, in case 4 years naman from the time the right of action accrues, injury to the rights of the plaintiff and upon a quasi-delict. So, you have 4 years to commence an action for damages. So, also, please take note that after the obligation becomes illegal or it has prescribed, yung solidary debtor who pays, he is not entitled to reimbursement. Let us say there is a written contract para sa utang, 20 years na hindi pa naningil yung creditor, tapos itong debtor 1, tatlo silang debtor, sabihin natin, 20 years na hindi pa naningil yung creditor. So, debtor 1 does not bigla siyang tinubuan pala ng konsensya. Alam niyang may utang siya kay creditor. So bigla binayaran niya yung utang ng utang nilang lahat. So let us say 6,000. So binayaran ni debtor 1 yung buong 6,000 kay creditor. So that is 20 years after the right of action accrues. So maybe 20 years from the demand made by the creditor. Nagdemand ng creditor pero hindi pa rin nagbayad. 20 years nang nakakalipas, bigla tinubuan ng konsensya si debtor 1. So, anong gagawin ni debtor 1? Babayad siya. Remember, he is no longer entitled to reimbursement or refund from debtors 2 and 3. Yan. Dahil nga nag-prescribe ng obligation, there is no more obligation to comply with. Remission naman of share after payment. This is at 1219. Medyo hindi ko lang nailagay. So anyway, share of a solidary creditor is remitted by the creditor after another solidary debtor has paid the obligation. So, creditor, solidary debtors, nagbayad na ito. Debtor 1 pays the entire obligation. Solidary kasi so full payment. Tapos, after payment, itong si creditor, ni-remit niya yung obligation. Let us say the remission is given in favor of debtor 2. Kasi medyo nabola siya ni debtor 2. But remember here that the remission is no longer effective because nung time ng payment ni debtor 1, the obligation has already been extinguished. Wala na eh. May payment na. Tapos na yung obligation. So, there is really here nothing more to remit. Tapos, itong si debtor 2 who gets yung remission cannot also ask for reimbursement from the other parties. Pero itong si debtor 1 who actually paid for the obligation can ask for reimbursement even from debtor 2 kung kanino binigay yung remission because the remission here came at too late. Yan. What else? 1220 naman, remission of the entire obligation obtained by one of the solidary debtors does not entitle him to reimbursement from his co-debtors. So what you have to remember here is reimbursement is available only if you pay something. If you pay nothing, you are not entitled to reimbursement. Again, creditor, debtors 1, 2, and 3. Sabi ni creditor kay debtor 1, huwag nyo nang bayaran yung utang yung lahat. Tapos itong si creditor, sabi niya kay debtor 1, huwag nyo nang bayaran yung utang nyo. So, ang saya ni debtor 1, ay, hindi na babayaran yung utang naming tatlo. Tapos itong si debtor 1, wise siya. Sabi niya, ay, very smart. Sabi niya, singilin ko nga si debtor 2 and 3. Kasi, magpapa-reimburse ako, ganun. But remember here, class, that debtor 1 is not allowed to get reimbursement from 2 and 3. Kasi, wala naman siyang binayad in the first place. So, this will apply only if the entire obligation is remitted. Now, lost, these are the rules in 1221. So, obviously, this will apply also if the object is specific because if it is generic, genus nunquam perit. So, the loss is without fault and before delay. So, obligation of the debtors are extinguished. Loss is due to fault on the part of any of a solidary debtor of one of them. All shall be liable. Solidary kasi sila, di ba? For the price as well as damages. So, this will not apply to money. Money is generic. So, anyway, mga objects siguro to ganyan. So, objects ito. So, innocent debtors can recover from the guilty debtor the amount they have paid, including damages. So, if they have already contributed. So please take note of number 3 class. Yung loss is without fault, but after the solidary debtors have already incurred in legal delay. So obviously, what we are trying to talk about here is legal delay. So here, the reason for loss is fortuitous event. Dapat, di ba, pagka fortuitous event, obligation is extinguished. But remember, the solidary debtors here are already in legal delay or in default. So, due to yung default on the part of the solidary debtors, the creditor can still recover damages from all solidary debtors. Now, this is what you have to remember. Yung guilty debtor or the guilty solidary debtor or the debtor who caused yung default or who is the reason for the default, he
can be liable to the innocent debtors or the debtors who did not cause yung default. Because it can happen na tatlo silang solidary debtors. Tapos sabi ng dalawa, oh, mag-comply ka na. Sabi, deliver mo na. Tapos itong isang solidary debtor did not deliver on time. So, ang nangyari, nagkaroon ng default. Then, even if after that, the object is lost by a fortuitous event, exception yun eh. Dahil merong default, may ground for liability. So, remember, this is without prejudice to the right of action of the innocent debtors against the guilty debtor. So, anyway, 1222, ito yung defenses which are available to a solidary debtor. Now, remember, tatlong klase yan. Defenses derived from the nature of the obligation. Defenses which are personal to the debtor who is sued. And number 3, defenses which are personal to other debtors.
So, the defenses derived from the nature of the obligation, ang mga example niyan is yung illegality or absence of cause or consideration. What else? Absolute simulation, which you will learn later on when we go to contracts. But for now, yung absolute simulation is void contract for lack of consent. So, ang absolutely simulated contract is para siyang fake na contract. Talagang the parties do not intend to be bound at all. So, joke lang, kumbaga, na contract. So, it is absolutely simulated. What else? Extinguishment of the obligation as when the whole debt has been paid, remitted, or has prescribed. So, any ground for extinguishment as found in Chapter 4. What else? Number 4, non-fulfillment of a suspensive condition if made upon the whole object or upon all of the debtors. What else? The statute of frauds. This we will learn when we go to unenforceable contracts in yun nga sa second part ng ating course. What else? When all the debtors were incapacitated to give consent, such as minor, insane, idiots, and persons under a hypnotic spell, or when there are vices of consent on the part of all of the debtors, such as when all were forced or intimidated or unduly influenced or were led into error as or there is fraud. And of course, res judicata. So anyway, yung mga ito, they are complete defenses. So kung halimbawa, let us take one, illegality or absence of consideration or cost. So let us say the object in an obligation is shabu. Yan. So let us say creditor, siya yung nagde-demand ng shabu. Tapos debtors 1, 2, and 3, tatlo silang debtor who are supposed to deliver yung shabu. So anyway, itong creditor na to, let us say nag-demand na siya from debtor 1. So remember here that debtor is debtor 1 cannot be held liable because the object here is an illegal object. It should not be delivered. It is contrary to Lamog PP. So here, remember, debtor 1 has a complete defense para hindi siya mag-comply sa obligation. Same is true also with debtors 2 and 3. They have a complete defense. So yun ang tandaan natin. What else? In case of absolute simulation nga, katulad ng nasabi ko kanina, si A at saka si A ay si creditor, tapos si debtors 1, 2, and 3, they executed a fake agreement wherein the debtors will pay 100,000 to the creditor. So, actually, hindi naman talaga sila nag-agree na may utang talaga yung mga debtors, except that, let us say, tinatry lang nilang mag-print ng contract, tinatry nilang magsulat yung ballpen or whatsoever the cost, but they drafted a contract na hindi naman talaga nila planong pasukan. So here, there is uh, absence of consent. So, fake lang yung contract. Wala naman talagang utang si debtors 1, 2, and 3. So, debtors sila. Air quotes yan. So, anyway, creditor, uh, supposed creditor demands from debtor 1. So, here, debtor 1 has a complete defense. Bakit? There is lack of consent, absolutely simulated contract, wala yung mga essential element, wala yung isang essential element. Remember, this is a void contract. Hindi ko kailangan magbayad sa'yo. Same is true with debtor 2 and 3. They have the same defense. What else? Let us try number 4, non-fulfillment of suspensive condition made upon the whole object. Yan. So, anyway, let us say hindi natupad yung suspensive condition, because remember, suspensive conditions will give rise to obligations. So if the condition does not happen, it is as if there is no obligation at all. So obligation, creditor, debtors 1, 2, and 3, the obligation is subject to a suspensive condition. Tapos hindi natupad yung suspensive condition, creditor demands from debtor 1. Of course, debtor 1 has a defense. This is a complete defense, non-fulfillment of a suspensive condition. The obligation did not actually arise at all. Same is true with debtors 2 and 3. How about defenses which are personal to or which pertain to the share of the debtor suit? So they are 4. Vitiated consent on the part of the debtor suit. On the part of the debtor suit, this is a complete defense. Incapacity to give consent on the part of the debtor suit. So on the part of the debtor na dinedemanda, this is, remember, a complete defense. Ano yung mga incapacity? Insanity, minority, etc. Non-fulfillment of condition imposed regarding his share. This is a partial defense. What else? Non-arrival of term regarding his share. This is a partial defense. So, itong mga defense na to, personal to the debtor himself. Now, let us say, class, creditor, tapos tatlong debtor. 1 is a minor. Debtor 3 is a minor. So, remember, class, may utang na 100,000. So, one way or another, itong si minor na involved dyan sa obligation na yan. So anyway, itong si creditor demands payment from debtor 3. Remember, debtor 3 being a minor, he has a complete defense. He is not required to pay for anything. Wala siyang babayaran. That is, remember, a complete defense on his part. Please take note also, class, of defenses which are personal to other solidary debtors. So, apat din sila. Remember before that this is a partial defense regarding the shares of others involved. So, vitiated consent on the part of the other debtors is a complete defense. Incapacity to give consent on the part of the other debtor, as when the one party, one solidary debtor is a minor or is insane, etc. What else? Non-fulfillment of condition imposed regarding the share of other debtors, and non-arrival of the term regarding the share of other debtors. This is again partial defense. Now, if you remember my example kanina, yung creditor, debtor 1, 2, 3. Debtor 3 is a minor. Now, remember, if creditor demands from debtor 3 has a complete defense which is personal to him. What is that? Minority. Hindi mo ako pwedeng singilin, minor ako. That is a complete defense. From me, you will get nothing. So, that defense is also personal to the minor. Now, what if yung creditor does not demand from the minor but demands from creditor 1 who is of legal age? So remember, creditor 1, he has an obligation to pay. So siya ay mayroong liability na magbayad. Now, he will be liable for, let us say, yung utang is 300,000. So he will be liable for 300,000. Remember, kung si debtor 3 na minor ang siningil ni creditor, debtor 3 is not liable for anything. There is a defense which is personal to him, which is minority, and it is a complete defense. Now, ito namang si creditor 1 who is of legal age. Remember, he has a
defense also, which is not personal to him, but it is a defense personal to other solidary debtors. Now remember, debtor 1 is liable for, again, 300,000, but minus the share of debtor 3, yung 100,000 na yan. Bakit? Because remember, here, yung debtor 3 is a minor. There is a defense on the part of the there is a defense on the part of debtor 3. It is a defense personal to debtor 3, but this is a defense which is not personal to debtor 1. So, kung sinabi ni debtor 1 na, sige, kasi kailangan niya talaga magbayad. So, debtor 1 must pay, but remember, less yung portion ni debtor 3. Kasi with respect to the portion of debtor 3, merong partial defense itong si debtor 1. Debtor 1 having only a partial defense, remember, he is liable for 200,000 pesos. Less yung liability ni which pertains to debtor 3 who has a complete defense which is personal to him. Yung defense ni debtor 1 is a defense which is personal, not on his part. So, it is a defense personal to other solidary debtors. So, anyway, that will be it for joint and solidary obligations. Please stand by for divisible and indivisible obligations. Thank you, class, and good night.